Hello everyone. This little tutorial is a quick tutorial regarding the student issue evaluation form. And I wanted to create this tutorial because this is a very important form that we're going to utilize in the class with regard to your team project in particular. But with that said, I want you to just take a quick look at how it's set up, because this is how you're actually going to organize your issue evaluation when you're completing it for your particular assignments. You are going to start with the issue. That's the first thing that you're going to be looking at. And when you look at the issue, you're looking at the legal question that needs to be answered. That means that here you're going to have the title that says issue. Maybe there's more than one issue in your particular case or scenario. I don't know. But nonetheless, that's what you're going to be looking at. The issue is the question. So it's not a thesis statement regarding the entire scenario or project or assignment. It is the issue, the question that needs to be resolved. For legal purposes, we like to use this word right here, whether. And we use that word because it takes an affirmative statement and it turns it into an issue, a legal issue for our purposes. So if you start your sentence with whether it was a violation of the Americans with Disabilities Act to not put in parking for the disabled, that would be your issue in the case. And then you have to actually determine, well, pursuant to the law, what is your answer going to be, which will take us soon to our holding. But that's how you're actually looking at drafting an issue. So it's very important to use the word whether, W-H-E-T-H-E-R. And remember that your holding, when we get to that point, is going to directly answer your issue. Now we go down to the next section, which is the facts. The facts are the circumstances that gave rise to the whole situation taking place. Why is the plaintiff suing the defendant? Why is the defendant being charged with a crime? What are the facts that gave rise to that entire circumstance? So you're not looking at the law, you're looking at the actual circumstances that occurred that caused the plaintiff to sue the defendant or caused the state or federal government to charge the defendant with a criminal wrong. So when we look at that, or it could be a civil wrong for talking about different areas like environmental and other areas, but you're looking at the situation from the plaintiff's standpoint when you're looking at identifying facts for the issue. Because there's always going to be facts for the issue which support the issue, and there's always going to be facts against the issue. And facts against the issue are those that are generally going to favor the defendant's standpoint. There may only be one or two facts against the issue, but there's going to be a fact nonetheless. So when you're looking at that, you're looking at what are my breakdown of the facts. And the reason I have you break them down is because I want you to be able to stay organized and think about, from a critical evaluation standpoint and a critical thinking standpoint, what am I trying to say? What am I looking at? What are my most relevant facts? Because when you are a CEO, you're in an upper management position, you're supervising employees, and you have a situation come to your attention, you have to determine what the objective, relevant facts are to the situation. You're going to have one side tell you one thing, you're going to have another side tell you another thing, and somewhere in the middle, you're going to determine what the actual facts are that occurred. And that's what we're looking at. We're looking at what were the facts that caused the whole situation to arise. Now you're going to identify laws and regulations in section 3. And your laws and regulations are just literally give me the name of the law, or give us the name of the law and where it can be found. So if we're talking about the Clean Water Act, the name of the law is the Clean Water Act, and it can be found in 42 USC, blah, 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 whichever code it can be found. If you're talking about a case, you're talking about Gonzalez versus Reich or something of that nature, you're talking about the title of the case and then the citation, which is where the case can be found, whether it's 42 Southern 2nd 2021, which tells me that it's in the 42nd volume of the Southern Digest of Cases, and it's found on page 2021. So that tells us where it can be found. So that's what we're looking at, and that's all you put in that section, because all the other information is going to go in the rationale section, which we'll talk about in a minute. Now, another very, very important section is your decision and holding. The holding actually answers the issue that you articulated and stated above here. That means that your holding should mirror your issue, answering it in the affirmative or negative. It's not yes or no. You'll lose points for saying that. Your holding or decision should literally mirror the issue. So, we stated earlier that the issue was whether the defendant violated the Americans with Disabilities Act by not having parking for the disabled. Okay? So, if your answer is that it did, then your holding is going to be the defendant did violate the Americans with Disabilities Act by not having parking for the disabled. That is literally your holding. If your holding were in the negative, then you would say the defendant did not violate the Americans with Disabilities Act by not having parking for the disabled. Now, if you notice, all I've done with the affirmative statement is take the word whether away. Otherwise, the statement is exactly the same. So I've taken the word whether out of my issue, and now I have my affirmative statement. But in the opposite, when we were saying that there wasn't a violation, what we just added were the negative connotations that needed to be in there, the verbs that needed to be in there in order to identify it as a negative. No, that wasn't the situation. That's not what was done. That's how simple it is with regard to answering the issue in the holding section, and you want to be direct. If for some reason your holding does not fit your issue, then you need to look at which one do I need to revise. Do I need to revise my issue, or do I need to revise my holding? I guess it's really going to depend on how married you are to either one of those and what needs to be revised and how it needs to be revised. Now, the rationale section is always going to be the longest section of your evaluation, because it's where you're going to go into the details of explaining how the court reached its decision, how you reached your decision as a team, or whatever the case may be. This is where you're going to articulate how you got there. And what that means is, I want you to look at this as if it's a closing argument. You're going to talk about the law, you're going to talk about your issue, you're going to talk about the facts, and you're going to talk about how you reached your holding. Now, what that means is, think about the facts, the issue, the holding, and the law as the soup to your rationale section, because the ingredients to your rationale section, which is the soup. And what that means is you have to take all that information down, you have to blend it all together so that you have a valid and strong argument as to why your holding is correct. And that's what the rationale section is. So you want to go ahead and discuss the law. You want to go ahead and discuss what facts apply to the law or what facts don't apply to the law, depending on how you're holding, which means that you have to go into the detail regarding the law. So that's what you're doing in the rationale section. You're never going to be able to complete this rationale section in less than 2 solid, full, strong paragraphs, but generally I think you're looking at least 3 or 4. Now, number 6, a little easier. With 6, what you're looking at is what went wrong. You know, where did the problem happen? So how could that have been avoided? And you're looking at it from that standpoint. What could the defendant have done to avoid the situation? Number 7 is your implementation plan. If you're the COO and CEO or whatever the case may be, and now you're tasked with coming up with organizational changes that are going to help your company avoid this situation from happening again in the future, you have to be valid and specific on what implementations need to take place. Just saying that we need to revise the employee manual regarding sexual harassment, that's not going to identify what you actually need to do in order to guide your organization on the changes that structurally need to be made from a management standpoint or leadership standpoint to ensure to the best of your ability that you can avoid this from happening again. Because remember, whenever you're dealing with issues, that have any legal ramifications, what is happening? You're taking time away from the business of your business, and you're taking money and you're having to put it in a different direction that you didn't want to have to waste in that direction. So think about that as you move forward, and if you have any questions, don't hesitate to contact your instructor.